Hey, good afternoon, everybody. My name is Chris, back with our little show here. I have a very special guest with me today. One of the most famous attorneys here in Birmingham, who probably handled the most prominent case in our state's history. His name is Mr. Art Haynes. I believe his father was actually the mayor, if I'm not mistaken. Um, anyway, Mr. Haynes, thank you for this opportunity for coming on and welcome.
Well, thanks. Glad to talk to you.
Well, so let's go back, Mr. Haynes, to that day. The church was bombed, and it took several years till things came to light, and the trial started. How was you and your father chosen to be Mr. Chambliss's attorneys?
Well, we had had a lot of success in defending criminal cases. We were James Earl Ray's first lawyer in the Martin Luther King assassination. We just had a lot of success, and truthfully, we're pretty well known in the Southeast and throughout the country. So he called us just like any other client called. He was arrested, in trouble, and needed a lawyer.
Mm-hmm. Going through that case and going through the evidence, I know that supposedly, from what I remember, he had a nephew, Carl Garrett, came over that morning wanting a shotgun. Was there any reason why he needed that gun that morning?
I don't know anything. Don't know anything about that.
Okay, that was just something I'd read. It just could have been here or there. I noticed that. I remember that there was Mr. Chambliss they'd found some dynamite that had belonged to him, but it was dynamite was wet, and this was a few weeks later. Was there anything that could tie him to that dynamite?
What dynamite are you talking about?
I think it was in a field.
There was some dynamite way years earlier before the bombing there was some dynamite discovered, as I recall. I mean, this has been years ago, and I
understand.
I haven't thought about it, but it was way years earlier, and to my knowledge, there was no connection between Bob Chambliss and that dynamite.
Okay.
I believe that's what you're talking about.
Yeah, that's exactly what I was talking about. So there was I'd read that there was some dynamite that was in the house, and somebody walked into a room, and this was a couple weeks before the bombing, and Chambliss got really angry and didn't want anybody to go in there. Do you recall that story? Or
I remember that testimony. Yeah, it was actually closer than a few weeks. Bob Chambliss denied that happened, and denied that there was any truth to it. So, that's all I know. I heard the testimony that it happened, and he denied it. So that's. I mean, bear in mind, my job was to defend the prosecution, not to sort through all of that.
Right. Yeah. Right. Yeah. You're. I understand. I'd read, and I'll get into this a little bit later. The night the bomb was supposed to be made, they were, if I recall, making some signs down at a local, was it a mechanic shop or sign shop or something?
I believe it was a sign shop, is what they said.
And there was really nothing besides, those four people, from what I've read, that could really tie them to this. I recall that I reading a car that matched the description of some of the people, but this was, 3 o'clock in the morning before we had street lights, and this was supposed to be from 100 yards away. I mean, how good of an identification can we make on something like that?
Well, that'd be up to the jury to decide. The lady that testified, I've forgotten her name right now, said that she recognized Bob Chambliss as being there. So that was her testimony. Apparently, the jury believed it.
Now, one thing that's always troubled me about this case, and please don't take this wrong. I mean, I think murder, anybody, nobody's been murdered or anything, but I was always thinking that, if you really wanted to kill a whole bunch of people, you'd have a bomb set off at high noon. I'd read that that trying to get ahead here, but it's a different case, that Cherry had said that he had lit the fuse. Well, from what I remember, with the forensics and the bomb, there was just a mess about how the timing went off. I mean, how long of a fuse would you have to take for a bomb for it to go off for 9 hours?
All right. So I believe you're probably overlapping and getting confused with the Cherry case and the Chambliss case. The Cherry case was tried years after the Chambliss case.
Yes, sir. I understand.
There was I don't know anything about the Chambliss case. I mean, about the Cherry case. Didn't participate in it. Didn't hear any trial. So in the Chambliss case, there was no fuse to be lighted.
Okay. I guess what I'm asking is, I'm sorry, I didn't mean to overlap. What I meant was this supposedly been a time demolition?
Yeah. It was the proof in the Chambliss case was that it was a timing device with a float in a water pail.
A float in a water pail. Okay, I've never even heard of something like that before. Now, when we know the nickname had gotten Dynamite Bob and Chambliss. Had there been any other things where they had tied him to actual bombings in Birmingham?
I'm trying to think. He had never been arrested. He was rumored to have participated in bombers in previous bombings. I don't know that he was ever actually prosecuted.
Okay. From my readings, I don't recall that either. Now, how did, of all the people that's going on, the violent crimes in Birmingham and everything, how did the government lock on to Cherry, Blanton, Chambliss, and Cash?
As I understand it, early on, they were the prime suspects early on, and they weren't prosecuted early on. The real prosecution came that there was a perception that when the bombing occurred, that it would be difficult to get a conviction. Later on, the Attorney General, Bill Baxley, decided that was a injustice that had lasted too long, and he reopened the investigation. And the timing was such, just as there was a perception at the time of the bombing that it would be difficult to get a conviction, Attorney General Baxley decided and rightly thought that a prosecution based on some evidence could and probably would succeed at the time Chambliss was prosecuted. Time had passed, the mood of Birmingham had changed. There was some perception that there was a need for Birmingham to begin to to reconcile itself from the horrible days of the early '60s. So that's sort of the way that began.
Isn't that, isn't that, I think if somebody commits a crime, but isn't that unfair that, we should sacrifice one person to try to heal sins of the past?
Probably so. If you look at it in that, in that context. But here again, if you have a fair trial in front of a jury, in these days of prosecutions, I see it now. It's always been true. There's a strong risk in criminal prosecutions that the defendant will either be acquitted or convicted for the wrong reasons, for reasons of public sentiment, reasons of vengeance, reasons of purging guilt. There are all kinds of social dynamics in play in criminal prosecutions, and they really have no real appropriate place in that. It should be based strictly on the evidence, but that's not the way things really work.
So as far as the forensics, what did they actually have against Mr. Chambliss?
Well, the forensics, they're the main as far as the forensics are concerned, there really wasn't much by way of forensics at all. It was Chambliss was convicted primarily on witness testimony. The nephew who later turned to a niece. By the time he testified, the lady that identified him at the scene of the bombing. Those.
That's it.
I think those were the basis of the conviction.
I had read that she had seen that, which to me, it's not a damning statement. She said that Chambliss said that nobody was supposed to die about the bombing, and when she testified for that. I guess somebody could say that is a damning statement. I didn't see it as enough for a conviction, obviously.
Well, the question is, did he plant the bomb? If he planted the bomb not intending for somebody to be killed, and it was a felony that he did that, and somebody was killed, then you have a crime. Then you have a murder.
That's okay. Another question that I always thought that was interesting to me. I read that when I guess what they transgender, or what, I don't even know how the terms are now. That when she walked in the courtroom, that Chambliss looked and was shocked, and it was either you or your father asked, "Who is that?" And what my question is the prosecution not supposed to turn over every witness that's going to testify?
Not in those days. Not in those days. Prosecutions and defenses of criminal cases were pretty much by ambush.
Oh, so they just totally ambushed you on that. So you've got basically the witness, her testimony there that has Chambliss there. So when and I even told
I didn't think her testimony was all of that credible, particularly in light of everything else. I think that the lady that General Baxley found from I think she was from Detroit that had seen claimed that she could identify Chambliss at the church early in the wee hours of the morning, and had apparently made the same statement years before at the time of the bombing. I felt like that was the testimony that convicted him.
Really? Even from that distance at that time of night?
Yeah, I mean the jury believed her.
Right.
That's that's just
That's how it goes with the jury. So when the prosecution rested, what was your defense?
well, a bizarre thing happened at that time. The plan was to put Chambliss had done nothing but deny that he was involved in it from the
Mhm.
beginning to us, and the plan was to have him testify, and we'd been over his testimony many times with it, was to have him testify and subject himself to cross-examination and deny it. And our whole theme of the case was that although Bob Chambliss was a mean old racist man, that didn't necessarily mean that he bombed the church, because there were probably 10,000 just like him in Birmingham at the time. Came time to for him to testify. Not only did he refuse to testify, but he insisted that we call some of his friends to testify as character witnesses. And we knew good and well that was disaster to him, but he had control over whether or not he testified and how to proceed. When Judge Gibson called on us for our first witness, and I told him to testify, told him it was his turn, he said, "I'm not going." I knew right then that that he was just a guilty, unrepentant old evil person. I took him to an adjoining courtroom, to the jury room, and told him, "Look, if you're not guilty and you want to win this case, the only way to do it is for you to testify. If you don't testify, you're certainly going to die in the penitentiary." And even at that, he refused to testify. So
Do you think that had you put him on the stand, you could have won that case or at least got a hung jury?
I don't know. Who knows in retrospect? The times were very difficult, and I think when you add in the factors that we had talked about earlier, the social factors of the time, I think that a pure acquittal would have been a very difficult thing in that case. Bill Baxley had done an excellent job of putting together the prosecution and the witnesses, and of course he's a marvelous courtroom lawyer, and I like to think we were playing even with him in the lawyering business, but I think in terms of the evidence and the social factors involved, he had very much the upper hand of that.
So, with Mr. Haynes, after Mr. Chambliss refused to testify, did you call any more witnesses?
Yeah, we did. He had taken over. Our plan was not to call any witnesses but him, and the jury either was going to believe him or not believe him. That was our whole case. He had taken over to destroy that theme. He knew what that theme and that theory was, and he had always denied it. Once he decided not to testify, I concluded personally that he was guilty. In fact, that was a watershed moment in my life where I decided I no longer could represent criminal defendants because some were just so evil that I just couldn't do it anymore. But he insisted that we call some of his old friends to testify ostensibly as character witnesses. We knew that was disaster and doubted their credibility and doubted them, but he insisted on it. So we called them at his insistence.
Did you ever decide to, and maybe he had immunity then, but for his position, but call Thomas Gary Rowe?
No. Chambliss said that. No, Gary Thomas Rowe had absolutely no connection with the case at all. Chambliss wanted to blame it on him and do. He was about half senile, and he was mean and he was stupid. So, yeah, he said that, and that's what he wanted to do. But there was no connection between Gary Thomas Rowe and this case.
Did he ever want to try to throw his other guys, Blanton and Cherry, under the bus?
No, he never. He always denied any involvement in the bombing at all. So no. The answer to that is no.
So, from my understanding, Bill Baxley gave his closing arguments, and one of the little girl's birthday was the next day, and he said give her a birthday present. What was your closing arguments?
Simply that at that time, all of our preparation, everything we had prepared to do, was out the window because Chambliss had changed the whole thing. It insisted that we go a different direction. So my argument was strictly that it was the credibility of the lady from Detroit, as you say, the distance involved, the time of the darkness, the years that had passed, and a fairly standard criminal circumstantial evidence argument. That was all that Bob Chambliss had left for us.
Mm-hmm. Now, from what I remember, the jury went out, and the initial vote was 11-1.
I don't know anything about that.
Okay, I'd read that the initial vote was 11-1, and then around noon that day, they changed their vote.
No, they went out one day, went out one afternoon, deliberated for a while, did not reach a verdict. We came back the next day, and they deliberated up until about noon the following day.
Okay, and I imagine during your appeals, did thing about time between trial, and I forgot how they word that.
Yes. We the main our main appellate argument and the main legal argument was that, and we had moved to dismiss the case, and had argued early on and from then on that the delay in the prosecution had denied him due process, and that's a fairly normal criminal argument that that time makes witnesses' memories fade, and it was true in this case that Chambliss had gotten older. We felt like he was partially senile. He rambled and people forget over time. So yeah, that was our main legal argument, that the delay in the prosecution was unreasonable.
Well, I had read that this was such like what you said, that he was such an evil man that when y'all went in to speak to his wife Flora, I believe that was her name, that y'all informed her that he'd been convicted, and
she was thankful for it. Yes.
So that she almost cheered that he would know that he would never be out of prison again.
It was just that's I have said that. Yes, it was only she and I were the only people there. But yes, that's true.
So that case right there just changed you as a person, that you could not represent somebody that evil.
I had a very fine undergraduate and law school education. I believed very strongly in the laws, the Constitution, and still do, and believed that it was people often don't understand what lawyers do. The you know People, even my own friends, would say, "How can you represent somebody like that?" Well, murderers, rapists, criminals are entitled to counsel. Our Constitution calls on that and sets out that everybody is entitled to counsel. By the same token, I always perceive that to be a lawyer's duty to provide counsel to people. For instance, if you have, let's say you have a bank robbery, a man holds, the robber holds up, shoots 2 or 3 policemen, rapes somebody on the way out, and then he gets shot and goes to the emergency room. The doctor doesn't say, "Well, does this person deserve to live or not?" No, the doctor does the best he can, because his duty as a healer is to try to save the person's life. Just like a lawyer's job isn't to decide whether somebody's guilty or innocent, or whether he deserves a given result. A lawyer's duty is to provide the best defense he can to a person charged with crime under the law. If he knows, for instance, that a person is guilty, the person has admitted it, then he doesn't want that person to testify. He can't put that person on to lie. Then what he does is insist that the state bear its burden of proof. So, and I felt like I could no longer do that with the right motives, the kind of vigor that a defendant or a person with a lawyer is entitled to. I decided I couldn't do that anymore.
Now, going into that case when Chambliss was arrested, and you went in over your initial interview and everything, did you feel that he was an innocent man?
I didn't know. I didn't make that judgment. I knew that he denied it. We didn't see any real evidence that he was guilty. So, that just wasn't my function. I had no strong opinion. He was old, and that's why the delay in the prosecution was of importance to us, because he was old. His memory was failing. In retrospect, whether it was a question of his memory failing or whether he couldn't get his story straight, I don't know. But at the time, he denied it so strongly. He was entitled to a defense, and he could pay our fees, so we defended him. I did not personally come to the conviction that he was guilty until that day in the courtroom.
Bill told me that one time we was having at lunch. He said that Chambliss said, "I'm not getting up there. I'm not getting up there." When they was going to call him. When the case finally went to the jury, was you 100% convinced you'd come back with a guilty, or did you hold out a hope that you had that one vote that would hang it?
Any lawyer worth his salt is optimistic, no matter how hopeless the case. When that jury room door shuts, he thinks he might have won it. We knew we had an uphill struggle, so when the you always hold out hope or expectation on a personal basis that you might have won it, but
if you had just and I know this is probably a hard question to answer, believing now that he was guilty, let's say you had a jury that had some of the mindset earlier, and you'd got an acquittal. How bad do you think that would have bothered you?
Well, that's what I was saying. It's hard to understand how a lawyer thinks. I won a lot of criminal cases for people that that I knew were guilty by insisting on all of their legal all of their legal rights, insisting the prosecution prove its case. So, and bear in mind, even if we had won that case, that was the death of Carol Denise McNair.
Right.
There were still 3 more cases to go. So even if we had won that case, I can tell you with the tenacity that and the timing of it, if we'd won that case, the likelihood is he would have stayed in jail with no bond, and we would have had to try the next case. So
That's right. I forgot about that. That was only one. Yeah, that was one that he had. Yeah,
that's
I'm
right.
sorry, I forgot about that. And,
Right.
and
So you know, the truth of it is, to win for the defendant 4 out of 4 cases,
odds are going to be.
would just of any kind would be a long shot.
Now, did was your father the lead counsel, or was you the lead counsel in that?
I would have been the lead counsel in the Chambliss case. My dad would have been the lead counsel in the James Earl Ray case. I was the lead counsel in the Chambliss case.
Did after because I've read some of your appeals that you had with him. Did you he was, and I've read Chambliss's notes from prison, trying to get lawyers, and said that y'all was just trying to collect the money, for his appeals and stuff. Did you stay in contact with Chambliss until he died?
No. He had once he was convicted and gone. He was, and he did what criminal defendants do frequently. Once they're in the penitentiary, it's a very normal and standard thing to say, "Oh, I didn't have adequate representation,"
Right.
and all that, and he did that. So that he was on his own. The answer to your question is no. We had once the appeal was over, we had no contact with him whatsoever.
Yeah. I've seen that a lot with people doing that. Just got to be a famous case in Birmingham. Now that was a question that when you mentioned that, because I had no idea until I really started studying this case, and like I said, I became enthralled with it, and I've got pages of notes where I've written stuff down and tried to keep up with stuff. I meet with Bill, I think, in 2 weeks. And by the way, Bill actually thinks a lot highly of you.
Well, he's mighty kind. I feel the same way about him. He's a great lawyer and a very honorable man.
That's a great way to put it. I mean, because the times we've talked and just my talking to you here right here, I could just you just seem like a genuine guy who would talk to anybody and tell them the truth. But I know this is kind of off the subject here. When I read this, I was totally shocked, and I think the way your father put it, when James Earl Ray hired y'all, that your father said something along the lines of, "There's more potholes in this case against this boy."
That's a whole different case. Ray, we were 100% convinced we were going to win that case. I don't guess you want to go into all of that right now, but no, that the prosecution could not prove. They were stuck with the theory that James Earl Ray acting alone killed Dr. King, and the evidence just totally belied that. So anyway, that's where that was, but that's a whole different case.
Well, and I've kept enough of your time today, but if you would allow me that opportunity, I would love to come back one day when you have time and discuss that case with you.
Well, maybe so. Maybe that'll work out.
And because when I first read that, I thought, wow, that's so great. And then and then I read the next day that he fired him and pled guilty, and I was fired y'all.
You got don't conflate that. That's a whole different story. Just you can talk about that. There's plenty of things you can learn about that. So
that sounds great, because me being I'm I'll say a student of the King and Kennedy assassinations, and even the attempt on Wallace.
Story. You got your hands full with the church bombing. So good luck to you. It's been a pleasure to talk to you.
And I'm gonna contact you again soon, Mr. Haynes. A month or two away. After things get calmed down, and we'll set up another time if permissible with you. And I would love to have another interview with you. Thank you so much for your time, sir. I greatly appreciate it. You've been very cordial. Couldn't think a more pleasant man to talk to. And thank you so much for your time. And I hope you enjoy your Sunday afternoon. I will be glad to, when I get edited and everything, I won't take out any words, but I'll make it work.
You're breaking up again, Jalen.
Okay, sorry. We will talk soon, sir.
Breaking up again.
Thank you very much.
To you. I enjoyed the conversation.
Thank you, sir.
Goodbye.
Goodbye.